Police in Louisville, Kentucky released videos of pro golfer Scottie Scheffler's arrest last week outside the PGA Championship.
What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. Well, it's officially over. The prosecutor in the Scottie Scheffler case has dropped all charges against the #1 ranked golfer in the world, but not before he made himself look like a complete moron on camera multiple times and worsened an already ludicrous situation, further embarrassing the city of Louisville. Now, before we get too far ahead of ourselves, let's catch you guys up to speed on what happened if you haven't heard already. Just as a general housekeeping matter, I have gathered a bunch of videos from different outlets and linked the channels in the description for the purposes of giving proper credit for the fair use of the stories. Please click the links, go review the material for yourself, and give the outlets credit for doing the good journalistic work they undertook in this case. Now, let's watch the videos released by various news outlets, and then we'll talk about what is alleged to have happened here.
A native North Texan and Highland Park High School graduate is charged with assaulting a police officer, but the videos released today do not show that in any form, and police say they are not aware of any video evidence of that moment that they claim the arresting officer claims happened.
This is our first and likely best view of the Scottie Scheffler arrest at Valhalla Golf Club last Friday in Louisville, Kentucky. The Metro Police Department released 2 video clips Thursday from a camera pointed towards the club entrance. The mayor and police chief discussed the video evidence at a media briefing.
We are not aware at this time of any video footage which captures the initial interaction between LMPD and Mr. Scheffler.
That point is critical because there are conflicting versions of what led to the felony charge against Scheffler for assault of a peace officer. Scheffler was arriving for his tee time at the PGA Championship as Louisville police worked a fatal accident outside the country club. Scheffler, a Highland Park native and current PGA World #1, says he was told he could still enter the course. But according to the police report, Scheffler allegedly ignored police instructions, accelerated, and dragged police detective Brian Gillis. That is the initial interaction missing from the video. What we do see is Detective Gillis banging on the driver's side window before removing Scheffler from the SUV. Minutes later, the dash cam view shows the detective and another officer leading Scheffler away in handcuffs. After Thursday's police briefing, Scheffler's attorney talked to reporters.
It won't impact my case at all. Our position's the same as it was last Friday. Scottie Scheffler didn't do anything wrong. We're not interested in settling the case. We will either try it or it'll be dismissed.
Now, Detective Brian Gillis is our complaining officer here, and he literally has more disciplinary actions on his personnel jacket than Scottie Scheffler has B's on a lifetime worth of report cards. Gillis has been suspended at least twice and has been found at fault in 4 separate vehicle accidents while working at LMPD. He got in trouble for an unauthorized vehicle pursuit and for running lights and siren and using his patrol car to do donuts in a parking lot with a intoxicated citizen in the front seat of his cruiser. You know, the exact kind of person you'd want to have, because he got so much experience with traffic crashes and stuff, to be doing traffic enforcement and directing traffic right after a fatal accident has happened. Now, after conducting a rigorous investigation of my own, I've developed a theory as to how Gillis's pants got ruined. Personally, I think what happened is that Gillis ruined his own pants by abruptly taking an enormous shit in them right after he realized that he just struck the #1 ranked golfer in the world in the shoulder with his flashlight without justification. And from there, he knew he'd need to fabricate the justification out of thin air, and I believe that's exactly what happened. Y'all watched the video. You saw what I saw. Did you see anything reckless or assaultive other than the conduct of the police officer here? I didn't. Was he moving like a guy who just got dragged by a vehicle? Was he limping? And then based on this false narrative that was conveniently not recorded on body cam because he failed to initialize it, Scottie Scheffler, who is maybe the nicest human being on the planet, ends up getting arrested and charged with felony assault on a police officer, reckless driving, and a couple other things. Scheffler's attorney, who is a BAMF, by the way, Steve Romines, asked the court to continue Scheffler's arraignment if it was like a 2-week delay. Commonwealth attorney Mike O'Connell argued that that wouldn't be appropriate under the circumstances because Scottie Scheffler didn't deserve a continuance, that he should be treated like everyone else. The only problem is everyone else gets a continuance when they ask for it. So let's watch some of that exchange in a hearing where Steve Romines makes a motion to move the arraignment date to June 3rd, and Mike O'Connell objects.
All right, so this is just an order. You're asking to remove or to change the arraignment date from tomorrow until June 3rd. Is that correct?
That's correct, Your Honor.
Okay.
That continuance to June 3rd would be appropriate in this case, Your Honor.
Okay, go ahead.
Judge, are you aware of the nature of this case?
I certainly am. I'm aware of the nature of the case. I am not a golfer, and I couldn't pick out two golfers on the planet. But I am aware of the nature.
Maybe you were out of town over the
I
last
am
week
aware.
or something. But, yeah.
No, I am aware.
So Judge Mike O'Connell on behalf of the Commonwealth, and I've been trying to think of the best way to express this to you, but we're here today to talk about an arraignment that is currently scheduled tomorrow in this court. Scottie Scheffler is not a name that a lot of people would know, perhaps if they didn't follow the sport, but it's not a name that is not widely known literally around the world. Okay, he's from Dallas, Fort Worth, Texas. He came up here to play in the PGA Championship. This incident occurred on Friday morning that gave rise to why we're standing in front of you here today. I think he left last night after the tournament concluded. He flies by private jet back to his home. Indeed, is it Fort Worth or Dallas? Do you know which one?
Judge, if he needs to be here, I'll have him here. No, this is, again, I assisted in arraigning or getting him out. In getting his bond set. I was not present when the arraignment date was set. As the court's aware, attorneys oftentimes are present when arraignments are set. That way, calendars and that type thing can be coordinated. I was not. I'm asking, the arraignment date was given when the bond was posted. I'm asking to continue the arraignment to June 3rd.
And I'm
with the same bond conditions.
And I'm responding to that
Okay.
motion.
Okay.
The rule says, as you are well aware, that if you are charged with a felony, you are to be present for arraignment and in all stages of the proceeding. If you're charged with a misdemeanor, that's not the case. Your lawyer can come in and represent you and do many things. That's not the case with felony. There are instances where, and I'm going to show you language from the Kentucky Supreme Court, an update from the Chief Justice back in March of 22. I've highlighted what it says there.
Okay.
When appropriate, under the right set of circumstances, when appropriate, the defendant may be dealt with
Remotely.
remotely, would be the word. Okay.
Okay.
I do not think this is a case that the defendant will be somehow put out, inconvenienced maybe for a short few hours, but I do think it is appropriate that he be present with Mr. Romines and at the arraignment, where obviously a plea of not guilty will be entered. We have not had the opportunity, obviously yet, to review a lot of evidence that's out there, and I think we would agree that there's a lot of evidence out there. Much of it will be agreed upon, some of it will not. But back to this situation, I think it's appropriate that he be here before the court to undergo an arraignment in your presence. I don't make this objection lightly. I make it very seriously.
I want to draw your attention to something here, guys. First off, I just want to say this prosecutor is not stupid. You may not know that based on the absolute garbage that's coming out of his mouth, but he got a law degree from Notre Dame. Now, that may not mean anything to a lot of you, but as somebody who went through the gauntlet of getting admitted to law school, it's a big deal. In fact, if I sent my undergraduate transcript and my LSAT scores to Notre Dame Law School, they'd suggest to me that I needed to go to a local priest for a confessional. They'd suspend my ability to take communion, and instead of a regular rejection letter, they'd send me back a literal picture of the Dean of Admissions wiping his ass with my transcript. Anyway, the point is you can't be a dummy and get accepted into Notre Dame Law School, let alone graduate from there. You can, however, become a government bureaucrat for decades with no accountability and become so wrapped up in that and the complacency that comes along with it that you forget everything you learned at Notre Dame Law School. And that's what's happened to this guy. He's been in an elected prosecutor position since 2008. He was appointed in 2008, but he won the election for the job multiple times since then. And before he was the prosecutor, he was a judge on 2 different courts. He's literally arguing an objection to something Romines is not asking for. And he's quoting Supreme Court rules related to the thing that he's arguing that, again, Romines is not asking for. Let's get back to it and you'll see more of what I'm talking about.
Maybe I'm confused. I feel like he's just asking to move the arraignment, not to make his client not here. So is that, you're
That's
just
correct,
asking
Judge. If
to move it,
we
not...
haven't resolved the case by June 3rd, he'll be here with me in court. That's you know.
So again, he's just asking to move the arraignment, not to waive his presence.
Correct.
Is that correct? Okay.
Yeah, that's the order.
Well, and I object. I think we need to get the arraignment done, and then let's begin the process of trying to see when and if this matter could be resolved prior to the next court date, and not move the arraignment out and then expect at the time of the arraignment, whatever is expected, that something is going to happen that's going to be a significant step or steps at that time. So it's not, this man should be treated like everyone else.
I couldn't agree more.
Okay.
But how...
And the Supreme Court has said when appropriate.
How would the county be prejudiced in any way if we move? I'm not asking, so I've thought about this, and I'm going to require the defendant to be present unless somehow there is an agreement made before court, and then I will still rule on it. But I will rule upon whether or not, at this point, if you're asking me if the defendant must be present, my answer is yes. I believe that the motion that Mr. Romines has on today is to move the arraignment. How will the county be prejudiced in any of anything if the arraignment is moved?
Judge, I don't think it's a question of prejudice is not an issue. It's when appropriate.
How
is this defendant to be allowed to appear at some other distant date, or apparently his arraignment and something else that may or may not occur on that date? I don't think that overcomes the when appropriate requirement that is required by our Kentucky Supreme Court.
So whenever I have set aside something as a summons, or whenever I set arraignment dates, I usually ask if the person is represented by counsel, something that's convenient for their calendar. Additionally, if they don't even have counsel, I'll ask the defendant sitting in my jury box when is appropriate for them to come back. I'm not so I pick an arraignment date, whatever's convenient for the court's calendar and the defendant and or an attorney if represented. So I do that every single person that comes before me. So I try to make it convenient for people's calendars if they have other things going on. So if you'll just make me aware of how it prejudices the county if I do grant, and again, my order as of this moment, unless brought before me again, and that's not what Mr. Romines is asking me.
Correct.
Mr. Romines is asking me to move the arraignment date, not waive his presence. So at this time, again, I am not waiving his presence. I am wondering why the county is objecting to his arraignment being on June 3rd rather than May 21st, if that's more convenient for Mr. Romines' calendar.
I simply think that is how the matter should be processed. It was set for this date. Mr. Scheffler, as we all know, was here for 6 days or however many days.
I don't know how long
Well,
Mr.
he was here,
Scheffler
he played
was
in
here.
the tournament, Judge, and he left last night
Okay.
and returned home in Dallas, okay? The standard is when appropriate, not whether we all agree about it, we all think it's a good idea, it all sounds good. It's when and if it's appropriate. And respectfully, Commonwealth does not think that this is appropriate to do that. So we don't have an agreement, Judge, and I don't think we're required to show prejudice. It's when appropriate.
No. And Judge, this is an adversarial system. They're on one side, I'm on the other. I made the motion, they're objecting. He keeps referring to when appropriate, which is specifically referring to remote appearance. There's nothing about inappropriate regarding moving a court date. It happens every day. And so Mr. O'Connell says, well, we don't want to treat him differently. Then go through and look how many cases are agreed to by continuance by the county every day. They are absolutely treating him differently. right? And they have no basis for it. He keeps referring to when appropriate. That language does not refer to motions to continue. It refers to remote appearance, and we're not asking for that, Judge.
Okay, side note just for a second. You notice the difference in their body language? Guys, I live in Tennessee. I only go near Louisville to bourbon hunt. I had never heard of Steve Romines before this case, but I'm telling you, based on this body language alone, this dude would wipe the freaking floor in a trial with this prosecutor. He's on the verge of losing his mind, and he knows exactly what he wants to say. The difference is O'Connell was taking 38 minutes to say 4 words, and Romines is using every bit of emotional energy in his body to keep from going absolutely crazy on this guy. Also, look at Romines' suit. That bad boy is custom. That's not some off-the-shelf shit, okay? No, sir. That suit was built around him. It's probably lined with photocopies of jury award checks printed onto the finest silk money can buy. He's rocking the contrasting gray Cole Haan Grants. That's how you're supposed to style and profile in the courtroom. Now look across the courtroom at our Commonwealth attorney here. Now he don't look like a slob or anything. I'm not trying to insult the man over his clothing. I'm just saying they ain't the same. You know what I mean? Like, you know when you watch a McDonald's commercial and you see that sandwich, man, and it's all put together and it looks so good and you're like, man, I want to try that sandwich based on how it looks, right? You just look at it and you know it's good. And then you roll up to the McDonald's drive-thru at like midnight on a Friday night, and the thing that they give you that's got the bun and the meat all in different directions and the ketchup slathers all over your hand when you go to open it, and it looks nothing like that yummy sandwich you saw on the TV. Well, the ad you saw was Steve Romines, and what you got through the drive-thru window when you rolled up at midnight on a Friday is Mike O'Connell. That's all I'm saying. Anyway, I'm saying that because I'm mad at O'Connell because of how petty he approached this. His approach to this has been almost as chicken shit as the original arrest was.
Mr. Romines, was your calendar consulted at the time when the arraignment date was set?
Okay. He was not actually in court. The bond was set and he was released, and so they did not consult with me regarding that date.
Okay, and I feel like you all still are arguing about different things, but
Correct.
I feel that since Mr. Romines' calendar was not consulted and he was already representing the defendant, that it would be appropriate to consult his calendar for the arraignment. So I will move the arraignment to June 3rd at 9 o'clock in the morning. And again, at this time, your client's presence
Correct,
is not
Judge.
waived.
That's understood.
This hearing shows exactly how chicken shit this prosecutor is. He shows how completely out of touch he is with normal people, because he starts off by insulting Scottie Scheffler and acting like that nobody would know who he is. He's the #1 golfer in the world. Now that's almost as insulting as charging the guy with a felony for no reason. But again, we're 3 days after the fact here. Now I know that most of you guys have never worked in a political office, but just trust me when I tell you that when something like this happens, the right people were notified immediately. The city of Louisville gets to host a PGA championship, and the local police department arrests and brings felony charges to the #1 star in the tournament. And I promise you, somebody is on the phone with the prosecutor almost immediately, especially when it followed a fatal accident earlier that morning and they probably already had to talk to a prosecutor. I mean, I still have THP troopers who haven't heard I left the prosecutor's office yet and who still call me at 3 o'clock in the morning to ask me about what they should do on a fatal accident, because I was one of the few people at my office who would answer phone calls at 3 o'clock in the morning. But trust me, something like this happens, all the important people know, and they know everything by 3 days later. So we're at May 20th here, and he's up here trying his best to die on this hill of not agreeing to a continuance, arguing something that's completely unrelated, and again, demanding that Scheffler be treated like everyone else, even though everyone else would have gotten a continuance under these circumstances. And then, to beat it all, yesterday, 9 days after he's thrown this big fit about him getting a continuance, he's given the following speech and dismissing the charges because he can't find a crime? Absolute BS. Let's watch this mess of a court announcement and then we'll come back and talk about it.
Thank you, Judge Delahanty. Your Honor, today I will be tendering to the court a motion to dismiss all the charges against Mr. Scott Scheffler. But if it pleases the court, I would like to offer a brief explanation on the record, please.
Of course.
Okay. Your Honor, I'm here today representing the Commonwealth because I recognize the importance of this case to our community. While I've worked closely with my great team, I want to make clear that the decisions throughout this process were ultimately mine. The events that led us here today began with a tragedy, and as most people know, of course, just after 5 a.m. on May 17th in a steady rainstorm, Mr. John Mills was struck and killed by a shuttle bus out at the location where these matters took place. I have a copy of Mr. Mills' obituary and a very good photo of him that matches what is said in the obituary from his family and others that pay tribute to him. Mr. Mills leaves behind a wife, 4 children, a team of grandchildren, and my hope is that there will be more attention soon paid to Mr. Mills and his well-lived life. Mr. Mills' family has designated the Bluegrass Center for Autism for anyone wanting to make a donation in his memory. The death of John Mills is not a part of this case before you, as you know, Your Honor, but this terrible incident set in motion a confusing and chaotic scene at Gate 1 of the Valhalla Golf Course. Mr. Scheffler was not informed of the fatality and was driving to the course prior to the playing in the second round of the PGA Championship. Prior to Mr. Scheffler's arrival, several authorized PGA vehicles were properly allowed to enter Valhalla through Gate 1. Mr. Scheffler's was one among the first vehicles to reach the point at which Detective Gillis was stopping car. The interaction that followed between Detective Gillis and Mr. Scheffler resulted in LMPD filing 4 charges. My team and I began reviewing evidence as it came to us following the events of May 17th. We continued to receive and to review evidence throughout that weekend and late into the following week. We continued to work through the long Memorial Day weekend and have brought this matter before the court at the earliest opportunity following our complete review. My office conducted our work in a thorough and expeditious manner. Rules of, quote, ethics the Supreme Court has adopted with respect to for lawyers as they practice. Section 3.8 in those rules is actually styled special responsibilities of a prosecutor. It says in there, in the commentary, the very first sentence, a prosecutor has the responsibility of a minister of justice and not simply that of an advocate. It further goes on to explain that the very first responsibility of a prosecutor under Rules 3.8 of the Kentucky Supreme Court rules requires that prosecutors, and I quote, refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. Therefore, based upon the totality of the evidence, my office cannot move forward in the prosecution of the charges filed against Mr. Scheffler. Mr. Scheffler's characterization that this was, quote, a big misunderstanding, close quote, is corroborated by the evidence. The evidence we reviewed supports the conclusion that Detective Gillis was concerned for public safety at the scene when he initiated contact with Ms. However, Mr. Scheffler's actions and the evidence surrounding their exchange during this misunderstanding do not satisfy the elements of any criminal offense. For these reasons, Judge, I now tender to the court a motion in order to dismiss all these charges in this case against Mr. Scheffler with prejudice. Thank you, Your Honor.
Mr. Romines?
Judge, it's taken me a long time to understand that when I'm winning, don't talk. So I have nothing to say, Your Honor. We accept it. We have no objection to the county's motion.
Fantastic. So ordered. So at this date, I will dismiss the matter, and it will be ripe for expungement within 60 days.
Okay, again, not a single thing changed in those 9 days except this one thing. They turned over every stone they could, trying to find any shred of evidence that Gillis was telling the truth, and they couldn't find it. They couldn't find one witness. They couldn't find one video. They couldn't find one piece of corroborating evidence to support what this guy said. They've charged the #1 golfer in the world with felony assault on a police officer. And 9 days earlier, they jumped up and down about giving him an extra 14 days to arrange his schedule to come back and be arraigned on this bogus charge. And they found not a single piece of evidence to support this case that never should have been brought to begin with. Now, ordinarily, I'd give O'Connell credit here for just killing the case and at least not proceeding to trial, if not for a couple of things. #1, he started the press conference by pandering to the victim's family, and he immediately followed that up with giving himself an enormous pat on the back for doing doing what he should have done. He started with this BS about the duties of a prosecutor and how it's unethical to proceed in the absence of probable cause. And all that's true. But you're not supposed to insinuate how good you are at things. You're supposed to let the public and the free market talk about how good you are at things. You're not supposed to be on camera using the courtroom as a place to do a press conference and giving yourself a big old pat on the back. The second thing is he went on and on about how the government bureaucrats worked tirelessly through the Memorial Day holiday to get this ready for the court hearing. My response would be, you were working as a service to yourself to save face because of the mess that the law enforcement submitting the case to you created. Don't worry about your friends at the Commonwealth Attorney's Office. They'll flex off the time next week and they'll still take the rest of their 15 federal paid holidays or whatever it is for the year. And then the third reason I can't give him credit for taking it upon himself to kill this charge, even though he wanted to take credit for being a wonderful ethical prosecutor, is because of what Steve Romines is getting ready to tell us in his press conference as to why these charges were dropped today and prior to the arraignment. Here's that video.
Condolences to the Mills family, because these kind of tournaments can't go on without people like John Mills working out there and volunteers and that type thing. And it's just a tragic situation. We were pleased that the case was dismissed today. Obviously was dismissed without prejudice, or with prejudice, which is something that we had required. We were prepared to go forward and litigate this matter. We were also prepared to litigate the case civilly at the time actually we were going to start beginning litigating it civilly on Monday, or whenever Scottie had to appear in court. We were going to begin the litigation regarding the civil matter. He does not wish to do that. He wants to move on, and he's obviously having a historic career.
Why doesn't he want to file a lawsuit?
Well, Andy, lawsuits are paid by the taxpayer. If he prevails in civil litigation against LMPD, who pays that? Taxpayers of Louisville. He doesn't wish the taxpayers of Louisville to pay him for whatever occurred. Also, too, litigation is a distraction for anyone. And the truly historic season he is having right now, being involved in litigation would be a distraction. And as we've learned, you all local know I was involved in Kenneth Walker's case. I was involved in David McAtee's case. Litigation doesn't change what the police do. We can sue them and continually bring in those litigations, and it doesn't change. If Scottie thought it would somehow make a positive difference, I'm sure he would be willing to do anything that would make a positive change in policing or anything else. We had lengthy discussions regarding that, as well as regarding the criminal case, and he understands it was a miscommunication. As Mr. O'Connell said, he wasn't aware that the fatality had occurred. He had been directed, as other players were, how to proceed into Valhalla. That's what he was doing. And, when this occurred, obviously tensions were high. As you can tell from the body cam audio that several of you asked me about in the police car on the way downtown, that is Scottie Scheffler. He is, as always, as nice and polite and respectful as you could possibly be. I can assure you, if I was in the back of that police car, I would not have been nearly as polite as he was. But that's who he is. And, the one thing about this possible criminal case, as I said, we were prepared to try the case, and a civil case. Every case is dependent on the quality of the defendant or the plaintiff. If they are likable, they are credible, and they are honest, then you have a good case. Scottie Scheffler, you cannot find one person to say a bad word about him. When he's in a police car after being falsely arrested, he is still a perfect gentleman. I can assure you, Andy Wolfson, you would not have been, okay? I mean, it is remarkable, the restraint and character he evidenced, not only during the incident, after the incident as he's being taken downtown, and in the press conference that day. Scottie Scheffler, we need more Scottie Schefflers in the world. Well, it's obvious he didn't do anything wrong. And as I've said repeatedly, the more evidence that comes out, the more it shows that, Scottie was a victim here. And I think everybody sees something like this happen and realizes they're one wrong turn or running into the wrong person away from going to jail themselves.
Steve, I have to ask you though, the statements that Scottie made after the arrest don't seem to fully align He admits that he got impatient and went too far.
No, here's what happened, is he is being interrogated after the most stressful situation of his life, right? And the officer is actually asking him leading questions and trying to get him to agree with them, okay? And that's why you don't talk to the police, because they are going to try to put words in your mouth. And that's exactly what they did.
But that was after he read his Miranda rights. He didn't
Of
have
course,
to speak.
he didn't have to speak. But again, he asked to talk to the officer. He wanted to explain to him what happened. However, they are trying to get him to confess to something that he didn't do. And the video evidence shows he didn't do it. That's why you don't talk to the police. They are not trying to get to what happened. They are trying to get you to incriminate yourself. And that's what they were trying to do to him. And he didn't incriminate himself. He continued to show the quality of his character by trying to diffuse the situation.
Steve, in that body camera video, he specifically says the words verbatim, he just hit me with his flashlight. Do you believe there are grounds for a lawsuit if he so chooses?
There are absolutely grounds for a lawsuit. He doesn't want to be involved. Again, because who pays? The taxpayers of Louisville. Scottie Scheffler doesn't want the taxpayers of Louisville to have to pay him a dime. He wishes to move forward from this case.
Do you think the officer was dragged?
No, he was not. There are multiple eyewitnesses to the incident. The actual initial contact that I've spoken with, I have statements from, that the county spoke, the prosecutor's office have spoken with, that confirm that he was not dragged. You believe they would have dismissed this case if he was dragged? No, they would not have. That did not happen.
So my closing argument is that Mike O'Connell was an embarrassment to himself and the state of Kentucky and Jefferson County. He looks like he hasn't tried a case in 2 decades. Why he decided to insert himself here against somebody who is a freaking rock star of a defense attorney, I have no idea. But first off, the courtroom is not the freaking place for a press conference. That motion that he made to the court should have lasted 30 seconds. It was obvious the judge knew what the motion was going to be. It was obvious that she was prepared to handle it and sign it and dispense with it. It should have went something like this. Judge, after reviewing all the evidence, my office has determined that the Commonwealth has not been able to establish probable cause in order to move forward with the charges. At this time, the Commonwealth moves to dismiss all charges against the defendant, and we ask that the court do so with prejudice. That's it. That's it. That's all it takes. By the way, with prejudice means they can't be refiled. If the charges were dismissed without prejudice, the Commonwealth could come back in and refile them again. But instead of doing what he should have done, he decided to do something no one ever does in a courtroom and give a 15-minute dissertation comprising maybe 3 total sentences and said that the state couldn't prove a crime took place. A fact that anyone with better than 2100 vision could see within 60 seconds. Again, he briefly mentioned the victim of the accident that morning, but that really had nothing to do with the victim. It was the Commonwealth that detracted from the victim and decided to dig their hooks into a public figure for no reason. And they should have known. It's not like Louisville is a small place. They have a 1,000-man department or more and a freaking helicopter, for God's sake. It's not like we're talking about Podunk, Kentucky. They should have known this was going to happen. His only purpose in mention of the victim is to try and appeal to the public in hopes that not everyone will see how they royally screwed this up. That's called pandering. And when you use the death of an innocent person as a platform to cover up for your own incompetence, that's insulting, to say the least. All of the political players here are running around trying their best to save face because this detective has embarrassed the city in such a terrible way, and they realize there's going to be a public fallout. The mayor's giving a press conference, the chief of police is giving a press conference, the prosecutor's giving a press conference, and they failed miserably in justifying their actions. Kudos to Scottie Scheffler for being a decent human being and being a better person than I would have been under the circumstances. The last thing I want to say is that this case should be further proof of what we all know. It doesn't matter how much money or fame a person has, the influence associated with money and fame pales in comparison to police power. Romine said it as well as it could be said. This is what they do. Liberty has become nominal, incidental, and acceptable collateral damage to governments that do not care about anything except retaining and exercising their unadulterated power. That's all for this one, guys. Please remember to like and subscribe and leave a comment on the video. If you have time, stick around and watch some other videos on the channel and leave a comment on them as well. It really helps the channel grow. Until I see you again, take care, always film your interactions with the police, and keep your evidence to yourself.